Great, thank you. Welcome, everybody. It is another productive and exciting day in Senate Economic Development, Housing, and General Affairs. Randy, we welcome you back from your big adventure with the First Lady. We want a full report later. And today we are going to pivot to the cannabis legislation, which has come to us from the House. And we're going to tee it up with the reporter of the bill, our own House Chair of House Government Operations. And then we're going to go to the people who are working on the ground with it. And then we're going to go to our legislative council. So let's start with Mike, who's going to frame it up for us.
Well, for the record, I am Representative Mike McCarthy. I represent the city of St. Albans, and I'm the chair of the House Government Operations and Military Affairs Committee. I was a reporter at H270, and Senator Clarkson, if it's okay with you, I'm going to give a couple of brief comments about sort of how things went in my committee, tee things up, and then hand it over to the experts, because you have the people who are really behind this bill in the room today.
Behind you. Give the people behind you.
So H270, this act relating to miscellaneous amendments to the adult use and medical cannabis programs. This is really a bill that, while we're in this early stage of the new adult use market, is nascent. It's really about tweaking, fine-tuning a few of the things that are kind of emergent at the recommendation of the Cannabis Control Board. So the policies that are in here really come from Chair Pepper and the Cannabis Control Board and the recommendations. And so it was my goal to really have this be more of a housekeeping kind of a bill and not really introduce any major new policy. There are a number of things in here that you'll see. I think some of the highlights that we spent some time debating and talking about. One is about the total package limit, which you may have read a lot about. I will say right off the top that this bill does not include any change in the potency. This is not about solid concentrates. It doesn't have any changes to the amount of THC that can be in a single serving. The one change that we made after considering all the packaging waste and other issues that go along with our unusually small limit on the total number of edibles in a container on THC of 50 milligrams, bumping that up to 100 milligrams, basically going from 10 units of edibles to 20 being allowed to be in a single jar. That's what we're talking about here. So the analogy we kept using in committee was, you know, right now you can buy 2 6-packs. We're allowing people to buy a 12-pack. So the container, the actual product is exactly the same, but it's just allowing more units to be in a single container.
Is that part of your reducing packaging?
Yeah, definitely. I mean, so literally what we heard in testimony was that our cannabis retailers are selling, you know, half empty jars of very expensive wasteful containers and people, you know, are often buying 2 or more of those jars because the total purchase limit is higher. So the public health benefit of only having 10 of those edibles in a jar versus 20, it was hard for us to find the real nexus. And what we had heard last biennium was, you know, what happens if, and the what happens if a child or somebody ingests 10 edibles versus more than 10, is that the idea that the packaging limit is going to prevent that from happening. We have gone in circles and debated that, and we settled on, we really should just go to the 100 milligram limit. It is a reasonable, it's a reasonable limit to have. So I imagine you'll hear other perspectives and testimony on that, but that was one of the things that we spent a lot of time debating, and came down on the side of, we should join the vast majority of other states that have an adult use market and go with 100 milligram.
So we take bulk purchases off the table.
Yeah.
Just joking.
Yeah.
Some of the packaging issues.
Yeah. So this is just one small change there.
Yeah.
Other things like increasing the number of plants that someone growing for the medical use can have, was a response to the limit especially with the way that folks grow, they're not being the opportunity to really get the harvest that they need, and Chair Pepper can tell you more about that. But I think that was another one where you're going to see this increase in the number of plants for the medical use that I think is something that you should take a look at and understand the reasoning for. But that wasn't one that we had a lot of debate about, but it was something that I think, will strike people, that we're allowing people to have both more immature and mature plants when they're growing for medical use. And I would say throughout the bill, the bulk of the language that you're going to see is about adding this new type of license type, the propagation type. So these are, people who are selling the clones essentially, and not mature flower, but it's the ability for folks to get a license to sell starts essentially. So seedlings and clones, so that people can sort of get a clean start and they don't have to buy those plants from the illicit market to get started. So that new type of license to be a cannabis propagator is a lot of the bulk of the words that you're going to see in H270. We, as the bill made it through committees, the other thing I would draw your attention to is that we first in House Gov Ops and Military Affairs wanted to add more conditions to the registry. So the conditions that could allow you to get a medical card. And there was, we had some recommendation after Human Services took some testimony to scale that back. The one big change that we did make was to get rid of the need for sort of the dual verification if you have post-traumatic stress disorder. That's the diagnosis. So not there, we in current law have a condition that someone needs to show that they're in counseling, that they're actively in psychotherapy. And so we removed that second requirement, so that PTSD is a qualifying condition like the other ones we have in current law. But we left the other things off the table in the amended bill that eventually passed the House. And I think that generally we punted on the major questions, both on fees and on qualifying conditions about the future of the medical market. But I will just say right off the bat, we really, now that we have the adult use retail and we have the medical seeing significant reductions in the number of people who are applying for cards, we need to think about how we preserve the medical use and how we support people who do use cannabis for therapeutic use, and the dispensaries that we have. What do we want the future of that market to be, given that there's this change now that they're experiencing? And I think the Chair Pepper will tell you a little bit about what they're hearing from the different licensees, but the impression that I think Ways and Means had in the House and that our committee had was that we're going to have to do more work on the future of what the medical use program looks like in the coming year.
Okay, can I just ask a quick question?
Sure.
So there is a future, there is a purpose to have the medical going forward?
I don't think we've answered that question in H270 is what I'm saying.
Right. I think you punted that one.
It's really,
And I think that what we need to hear from the control board
Yeah,
I'm
curious about that.
and from Michelle.
I mean, you don't have to answer now, but obviously.
Michelle, do you want?
Well, I did just want to add that there was language in when you set up the commercial system in 2020 in Act 164, there was a statement by the General Assembly of the value of the medical program. And it's the intent of the General Assembly to have a robust medical program at the same time as continuing on and pursuing an adult use. And so you would need, that is kind of stated in there that you're supposed to be adopting policies to support the medical program. You can certainly go back and change that, but that's the way it is now.
and I think there are policies here that are tweaks, the plant number of plants that folks can grow and some of the other policies that are in here, but that fundamental thing of deciding on what the fees should be for dispensaries in the medical program Those are some of the requests that we didn't take action on. So the Cannabis Control Board had recommended a decrease in the dispensary licensing fees. Our committee approved that. Ways and Means, the House decision that we acquiesced to was to really have a more robust conversation about fees for the dispensaries next year. We did take one recommendation here, which was to have people who have lifelong conditions, diagnoses that qualify them to get a card for the medical program for the patients, to have that be an every 5-year renewal instead of an annual renewal. Just the waste of having somebody have to make a doctor's appointment and go to them to, sign off that they have a condition that they're going to have for their entire life.
Why didn't you guys do that? That seems pretty.
We did do
Oh,
that.
you did do that.
Yeah,
okay.
so that is one change that we did make. So the big fees for the dispensaries, we punted on that. We're going to take a holistic view, is what our Ways and Means Committee suggested that we do next year. So we left that question off the table, but the one change we did make in the medical program in regard to fees was to allow people who have those lifelong conditions to only have to renew every 5 years instead of every year. That does have a little bit of a fiscal impact. If I recall correctly, it was somewhere around $120,000.
My guess is pretty modest.
Yeah, it's not, it's sort of de minimis, but it's still.
So that is the huge discussion on the medical dispensaries. And I mean, just because it was created to enable people to access marijuana for medical use. And that is a whole good conversation about whether we need two markets and how we can streamline them. And I assume that we are going to turn to the experts to figure out how we do that. Or anyway, we had one because we couldn't have the other, and now we have the other, and somehow we need to figure out how to streamline this.
I would say if there was any deficiency in our testimony on the House side, I would hear from more patients and patient advocates and people who actually use cannabis for therapeutic needs. You'll obviously hear from Chair Pepper and others about the sort of specific needs that folks who are using therapeutic use that won't be met by the adult use market as it currently is constructed today. But I think that that there is a need for a number of Vermonters who use cannabis to alleviate symptoms and for therapeutic uses to continue to have a medical program. As Attorney Childs said, that is the intent of the General Assembly was not to get rid of the medical use program in the setup of the adult use retail market. So we've got, I think, to continue to, tweak, but H270 is not meant to be any, earth-shaking. This is meant to be kind of a housekeeping bill that sort of solves some of the low-hanging fruit issues and some of the bigger questions I think we're going to have to continue to noodle on, but we want to allow there to be at least a full year of the adult use retail market before we make that big changes.
That's brilliant. How restrained. I think that's in all things, some restraint in the first year or two is a thank you. Any questions for Mike before we move on? Okay, thank you very much. And what was the vote in committee and what was the vote on the floor?
Yeah, our committee was 8-4 and it was a voice vote on the floor for this one. So this was not a roll call vote.
Ah, okay.
Thank you for having me.
Thank you. And well done. And Pepper, we welcome you.
Oh, thank you. For the record,
You know everybody
I
here.
do,
Have you met
yes.
Wendy? Yes.
A while
I
ago.
was here in January.
Oh, that's right.
Dude,
Gosh, it
so
seems like
basically-
so long.
It really-
was a long time.
I know. It does feel like a lifetime ago. For the record, James Pepper, the chair of the Vermont Cannabis Control Board. And, this is a very rapidly evolving industry. Since I was here in January, there have been major changes both at the federal level and the state level. For instance, the DEA very recently has determined that certain hemp-derived cannabinoids are Schedule I substances. These are legally grown hemp plants that have It is that their portions of their kind of synthesized cannabinoids are now considered Schedule 1. The FDA has said that hemp producers.
Sorry, for those of us who are not absolutely completely have memorized every one of these things, does that mean they upped the classification and or lowered it? I mean,
They've said that portions of the hemp plant are now illegal.
right,
Yes.
that's what I
Yeah.
understood, that's what I thought I understood. So, which is not a great thing.
Well, it just shows that every day this industry changes and it's
Yes.
based on decisions at the state and the federal level. And there's very little movement legislatively at the federal level. So
Right,
a lot
there
of this-
continues to be good.
Yeah. a
And
lot-
yet that piece is not helpful.
Well, it just complicates everything in our lives, because you have a lot of people that have legally grown hemp, and they're creating hemp-derived products, and now those are now considered the same as a high THC product.
Right, so we've already heard from our former colleague. Who's a cultivator? John,
Oh,
right,
John. Okay, yes, yeah. Senator Rogers, yes.
Right.
So will you tell us more about that at some point, or is now the time to ask questions, or do you want me to? wait?
why don't you,
I would just like to know why
Yeah.
at some point.
yeah, and the implications of it, it just, it's
Yeah.
complicating your life because of,
Yes, I mean, we did write a report on how the state should handle these hemp-derived products, because really, the federal government just said, and this is very much a tangent to H270, but the federal government said the difference between this Schedule 1 substance, marijuana, as it's classified in the Controlled Substance Act, and legal hemp is the amount of THC that's in it. And, a cannabis plant, if you just let it grow, will eventually reach levels of THC that would classify it as a Schedule 1 substance. So you harvest it early in its life and it's legal. If you harvest it later, then it's illegal. What hemp producers are doing is they're taking their legally grown hemp, they're isolating certain cannabinoids and they're synthesizing them, and they're creating intoxicating substances from them. Like Delta-8 is one that we know quite a bit about now. States across the country are now banning Delta-8. The DEA said, yes, Delta-8, which even though it was produced from a legal plant or legal, is now a controlled substance as well, and should not be sold in gas stations or supermarkets or online or anything like that.
which it had been.
Yes, it's very challenging to kind of stay ahead of all of the various hemp-derived synthetic cannabinoids, that are intoxicating.
Okay, let us go back to
Yeah,
this,
yeah.
but I think your point and your illustration is a good one, which is things change.
Was the hemp cigarettes I heard about that were being sold?
We don't allow them in Vermont, I should say,
Oh,
in a regulated sense.
Buy them.
Yeah.
Well, you might be able to, but maybe not legally.
You gave us the authority to regulate hemp-derived products. We need to promulgate a rule around it, and whether that needs to be an emergency rule is something that we're debating internally.
I just wanted to tax them.
Well, yeah, that's it. We just don't know the long-term impacts. There's not a lot of, studies, inhalation studies about the effects of Delta-8. and
I mean,
synthetic cannabinoids.
If you're inhaling anything into your lungs, I think we can assume that it's not a good thing. I can't think of anything other than oxygen that you inhale that is good.
Yeah. I would say, on the local front, I was just going to paint a very quick picture. The CCB has approved over 400 licenses. We have 400 businesses here in Vermont. There's 77% of our 295 cultivators are these tier 1 small cultivators, which would be considered, our tier 1 doesn't even register on most states. And yet on most states, adult use system is 1,000 square feet or less. There would be a micro license or not even registered in most states. And yet there's 77% of our cultivators.
Sorry, was you for over 400 retails?
No, this is all from the entire supply chain, cultivators, product manufacturers, wholesalers, testing labs, and retailers, all combined. It's it's just shy of,
400 licenses.
yeah. We have 295 cultivators. So the vast majority of our licenses are cultivators.
And then how many retailers licensed do you have?
I think it's 46. Actually, I have it right here.
That's okay. That gives us a rough sense.
48, and we just approved 5 more at our last board meeting. So we will have 53.
But that's a lot of cultivators.
You know, we're keeping, you know, I think you all remember that cannabis can't move across state lines. And so it's really important for us to keep a very close eye on the supply and the demand. And we, you know, engaged in economists to help us determine what the demand for cannabis in the state was. And we're keeping a very close eye on how much cultivation we have to avoid what we've seen in Oregon, you know, what we saw nationally with the hemp market, which is just, you know, around harvest time, there's a price crash, you know, and we don't want to see that here. And there's no legal outlet to move cannabis if there is an oversupply in the Vermont market. There's no way to kind of legally move it to another state where there might be, you know, there might be a supply shortage.
What, may I just ask on that, as we look at the retail market, which is we're doing part in this bill, what's the shelf life? I mean, of cannabis products?
You know, you can store it. I've asked this question quite a bit. I mean,
Because
you can
I mean, if
convert it
overproduce,
into,
is it-
yeah, if you can convert it into a cannabis product, like concentrate, you know, the shelf life extends tremendously. But, you know, if you vacuum seal it or nitrogen seal it the way that we've seen, it, you know, it can last up to a year. I know, you know, some people might debate that. We have a cultivator right behind me who could probably speak to it in more detail, but it was something I was talking to John Rogers about earlier this week, actually, how long, you know, can your outdoor supply last? And he said, you know, if it's stored correctly, it could last almost a year.
Which doesn't keep it necessarily forever if there's a glut in the market.
No,
Right.
exactly.
Got
And that's a message that we've been trying to push, particularly to our outdoor cultivators, is you need to have a plan to ride out a price crash in the late fall. You know, storage, converting to concentrate, et cetera. You know, the CCB, fundamentally, our mission is to administer this program safely, equitably, effectively. Those are the, that's in our enabling legislation. We see this as ensuring that products have been tested and are free from harmful contaminants, protecting youth from either accidental exposures or, you know, targeted advertising, and really creating some common sense regulations and providing education and assistance to our licensees. You know, I mentioned this isn't a traditional market. You know, there's no movement across state lines. There's no banking or there's no real financing options for folks. So there's no lending in this industry. Bank accounts are incredibly expensive. There's no admitted insurers in the state. All insurance through surplus line insurers, meaning that they're just wildly expensive and they have a lot of exclusions that wouldn't be allowed in traditional insurance markets. And you know, we really, in this state, have relied on small scale businesses. Vermont owns small scale businesses. And so the board feels a responsibility to make sure that the folks that jumped into this industry aren't, because they put up their own money and their own capital and their own sweat equity, aren't in a worse position, you know, 2 or 3 years down the road than if they had just stayed on the illicit market to begin with. So we have to thread this very narrow needle, you know, balancing these competing priorities. And, you know, it takes a lot of vigilance on our side. And very importantly, it takes vigilance on the part of the legislature and a commitment to looking at this issue, looking at these statutes every year and fine tuning them and thinking about market expansion. You know, it's not really in our purview to advocate for market expansion, but I think, you know, one of the benefits of this bill or this issue being in economic development is you can hear from the people that need access to market, you know, cultivators and others, and you make tweaks. You know, the bill that you have before us doesn't do any of the big policy changes that that have been asked for. It doesn't do things like, allowing sales at the farm stand or allowing delivery. At this point, when we have less than a year of experience in the cultivation, we have, I think, just over 6 months of retail sales. I think what we need to do now is provide stability and clarity. And I think that that's what this bill does. Brendan will go through, or Michelle, I guess, will go through the substance of the bill, and Brendan will go through the rationale. For why we ask for these things, but really these are just fine tuning the current set of conditions, and it doesn't kind of change the major policy decisions that have been made. That being said, there are, that the House did not, with everything going on, did not have a ton of time to consider certain advocate requested amendments. And I think that there's two that I would like to highlight, because I do think that they relate to our equity mandate. The first relates to the Cannabis Business Development Fund. This was a legislative created pot of money administered by the Agency of Commerce and Community Development to help support businesses that are owned by people who have been disproportionately harmed by cannabis prohibition. Many cannabis growers are excellent at their craft, but they have very little experience running a business, paying taxes, and there's an incredibly complex area of the tax code when you own a cannabis business. Frankly, they have very little history of being in a regulated industry, let alone one of the most highly regulated industries, because of the federal illegality of this. This is compounded by people that have these criminal convictions that have been, maybe pushed out of traditional professions or are underemployed. A lot of times a criminal conviction means you don't have access to higher education. You may have been denied a loan to start a business or get a mortgage. And so, the legislature recognized these kind of, you said support, prioritize people who have been harmed by cannabis prohibition. And yet, these are the folks that need the kind of technical assistance and support and access to capital the most. So you created this Cannabis Business Development Fund. So we earlier this year submitted a legislative report on the overall health of the social equity program and what this fund has been used for. The one thing that we've heard repeatedly in our board meetings and just in kind of public comments to the board is that this funding is critical. This fund is essential.
What's the size of this fund?
So it started out as $500,000. And our report kind of explains how that money was used. It's essentially being used to provide business assistance. We hired their ACCD contractor with a consulting company that has expertise in cannabis businesses. And so social equity licensees have access to kind of some technical assistance from this consulting firm. And then there was kind of an ability to apply for grants if you're a social equity applicant, up to $5,000 for your business needs. And how much money is left in the fund, I think Brendan may know the exact number, but it's not administered by us. But we're
how's it replenished?
It's not. It was a one-time contribution.
And how many people have availed themselves of it? I guess last spring. Okay, we'll focus on that because. But the cost of assistance doesn't cost anything for it. Well, we'll check with her when she gets there. So that's the first ask is the first ask is to
either replenish the fund or have a dedicated revenue source. And again, I really don't like to tell the legislature how to spend its money, but we have an equity mandate, and I feel like there is no equity in this industry if only independently wealthy people can participate. And the kind of cruel irony in this instance is that it's because of our relationship in this country with this plant and the harms that caused that the folks that we've invited in don't have access to capital and they're not independently wealthy.
Madam Chair, just real quick,
Yeah.
is that in your report?
It is the recommendation to have some sort of replenishment or dedicated revenue source for the cannabis business
We
development.
just asked Scott,
Okay.
Scott, do we have that report on our website? If we could,
I submitted it the first time I was here, but I'll resubmit it for
I
today.
think.
That'd be great,
Yes,
get it to
yeah,
the top of the.
Yeah,
Yeah.
and it's also on the
No, but it-
legislative reports website, but I'll make sure it's just under my name for today.
that would be great. That would be terrific.
So
So that's the first
that's the
ask,
first issue.
is the fund
is
and
the-
how it's refunded, how it's replenished. Okay, second ask.
And the other issue that didn't get resolved in the House, but they heard a bit of testimony, it's just a complicated one, is how much zoning authority municipalities should have with respect to outdoor cultivation. Again, if this were hemp, which is the exact same plant, cannabis sativa plant, the answer would be local zoning doesn't apply. I know that the state versus local authority was debated when this bill was being considered back in 2020. But at that time, the whole issue was largely theoretical. And now that we actually have cannabis licensees that are being affected by local zoning to the point where, they're potentially going to be run out of business, I think that this issue deserves some discussion. We have 246 towns. There's probably at least that many differing opinions about how cannabis should be zoned. It's hard for the CCB to kind of really live up to its equity mission if there's that kind of geographic disparity about how cannabis is outdoor.
So do we have some, I assume we have some illustrations of this and a proposed fix? Do you have a proposed fix for this?
We are working with Michael O'Grady in the Agriculture Committee. There's been testimony in the Agricultural Committee.
Right, and so this is a discussion for us that because we sort of share jurisdiction on this bill. And Bobby and I spoke this morning about it because we would love to have them do a flyby on the cultivation pieces.
Yeah.
And I think they'd love to do that. And so I think we should just figure out which pieces we want to, but the zoning pieces, obviously, we would have some input into.
I think so too. And when you mentioned flybys, if you don't mind, this is my last thing, or not.
I didn't mean it in a derogatory way.
No,
I meant-
no,
I
no.
meant have them,
No,
without giving them possession.
Oh,
We
no,
want
no.
them to have those sections
Yes.
to review.
Right, and I was gonna say that this bill, because it makes changes to the medical program, I think traditionally, the humans, the
Health and
healthcare,
welfare.
yeah, would want at least to put their eyes on it. and
Okay,
give
so
you a
let's
strong-
identify these sections.
Yes.
And we'll get them and ask those chairs to look at them in fairly timely fashion.
Yeah.
Even we have 4 weeks to do all this work.
I know, and I should say that I think by rule, finance has to take it. I'm very
Yeah,
glad that, yes.
so, yes, we
Yes,
luckily have 3
yes.
members of
Yes.
finance on this committee.
And,
So they're well prepped before they get, before they discuss it.
and it probably needs to pop into appropriations as well, just to give you a sense.
Just
of
maybe,
the timeline.
yes, because we affect the revenues in this bill, it seems like, and it looks like we may be asking for an appropriation and or figuring out how to replenish something with something we already have. Either way, it's an appropriation, right?
So I think it probably makes sense to turn to the substance of the bill with your lawyer. I would just, because we spoke about the medical program, and yes, it's an open question, is the medical program even viable anymore? Now that there's an adult use program, we've seen that there's a high watermark around 2018 of 5,600 patients. We're down to 3,700, precipitous drop. And we don't know if there's a floor. I would say that there are benefits to the medical program that the adult use program does not offer. And if we're gonna just kind of decide that these two programs should be merged, there's certain patient protections that I think we would want to see in place before we just give up on the medical program. And first and foremost really is confidentiality. There's rules about how many people can be in a medical dispensary at a given time. I mean, the stigma of cannabis use still is very present. you know, a lot of regulated professions look down upon cannabis use. If you're a doctor, if you're a teacher, if you're a nurse, et cetera. And the patient confidentiality is very important. There's also products that are available on the medical side, which are not available on the adult use side. And so we would need to close that gap if we're going to kind of significantly change the medical program. Medical program is allowed to do delivery for people that are kind of bedridden or just otherwise incapacitated. There's access to caregivers. You know, a lot of people on the medical side can't afford to go to a dispensary, so they grow their own. You know, they do home grow, but they can't really always, they're not really able to just, you know, spend the time that it takes to grow a plant. So they rely on caregivers to help them with this. And then, of course, you know, probably the easiest thing to fix would be that they get to purchase tax-free at their medical dispensaries. You know, that could change with the legislature. You know, that statutorily could fix that problem. But you know, these other aspects of the medical program are vital to the patients. They rely on it. And to just kind of throw out the program, I mean, the problem is, of course, if the patients drop to a certain number, the medical dispensaries, which are all for-profit, you know, are just going to say it's not worth it.
So did they discuss, I mean, I know we don't necessarily want to have a task force, but we in 4 weeks, I know are not going to have the time to discuss this, and it needs a fulsome discussion. But it does strike me that it is time for us to figure out how to streamline them and how to protect medical patients, but also how to not have competing retail options. Did they discuss setting up a task force to come up with a recommendation for us on this? And or should we do a task force, or should we give it to you to recommend a way to integrate the two and have one system where we can accommodate both kinds of both patients and purchasers?
I think that we can do it internally, and I'm
Okay.
committed to doing it.
So if we charged you with that,
You can certainly charge me with that formally, you know, because we're gonna do it no matter what. The recommendations that are in page 270 now in section 13, which is the medical section, all came from a number of public hearings around the medical program from patients and caregivers and, you know, medical dispensaries. So everything that's in this bill came from one of these task forces, but they're really minor compared to the kind of problem.
it looks like we need a more major.
Right. It
Systemic
needs to be
fix.
reimagined, you know, if it's going to survive. And, you know, it doesn't need to survive in its current kind of brick and mortar 5 dispensary form. But it certainly offers value to patients that the adult use program is not going to offer.
So does section 13 charge you with coming back to us with a proposal on how to integrate the two?
It does not, but
Okay.
I do have some thoughts, but you know, again, this is one of those issues where we need the kind of summer and stakeholder input to get it right. And so,
Got
yeah.
So I think we should walk through the bill and still understand the full bill. But I think when we come back to this and have the next time we meet together, I think we would be interested in entertaining a recommendation from you on how we expand section 13 or have another section 13A that might charge you with this work and coming back to us with a recommendation after you have some time.
I just had a question.
Yeah.
Have you had any reports of animal poisoning? I know Vet Tech, who says they are seeing increasing numbers, basically of dogs who are coming in poisoned from eating cannabis that has been composted. People do whatever they do, put the leftovers in the compost pile. And apparently I could think of some breeds who would really love to eat that because they eat everything.
Or let alone the raccoons.
Yeah, well, some of us might not mind that, but,
I've heard anecdotally that exact
Yeah.
point as well. You know, we have pretty strict restrictions on how the cultivators, you know, deal with their organic
leftovers,
waste.
yeah.
You know, the home growers, we don't have any jurisdiction over. You know, we the thing that we pay very close attention to are the kind of accidental exposures among people,
Right.
like poison control, but I don't think there's any, you know,
In
systematic.
this day, when people talk about being pet parents, it seems like maybe a warning, like, be careful, your stupid Labrador
Yeah.
will eat this stuff.
Yeah, I actually think it is on our warning about safe storage
Yeah.
for the purposes of, you know.
Never mind, I mean,
and
kids and
pets.
gummies,
Yes,
dogs and
yes,
gummies.
yes. The new label has that.
Yeah.
Yeah.
Okay.
Do you have anything further? I just had a communication from our chair, so.
I will be here all morning, so, you know, but I think it's probably most effective use of your time to just hear the actual substance.
Great, I think so too at this point, but I would, if you, I mean, I'm sure you've thought about how to do this, but we might work on some language on
Yeah.
how we move that issue forward in this bill and give it to the right crowd to do.
Yeah.
It sounds like giving it to you guys makes the most sense.
We will be doing it one way or another, and to formalize it and have a, you know, official report come back to you is probably the best way to do it.
I think it's the best way to do it, and I think we don't have time to actually dig in that deep
Yeah.
for us to do a good job on that. So I think it would be
Yeah.
best if you guys came to us with an addition in that section, an expansion.
Madam Chair, just a quick.
Yeah.
I do think it makes sense if you guys can do the study, but, Representative Mark Cook asked, or suggested that we hear from, medical McCarthy, sorry. Which wasn't on tape. Do you have suggestions of folks that we should speak with, and maybe you can just let,
Yes.
Scott know?
Oh, yeah, we have the witness
Yeah.
list from the last
Last
go
one.
round, and anybody else you think we haven't heard from, let it, obviously, we're just beginning.
Sure, and they all have very different stories. as
Sure.
well. And, you know, some of them are caregivers, some of them are patients, some of them have caregivers, small children. So, you know, there's a lot of variation amongst the testimony that you would hear. All of them are benefiting from the medical program.
Great.
Could not be submitted by an adult system.
Great, so you can help us get a good sampling.
Yes, absolutely.
Perfect, thank you.
Thank you.
Thank you, Pepper. Michelle.
Good morning.
Good morning.
For the record, Michelle Childs, Office of Legislative Counsel. And if I can just say, it's so lovely to see Senator Cummings still with her knitting
I'm
needles.
still here.
It was making me think back, my favorite gift when I was pregnant with my first daughter. Senator Cummings was on Senate Judiciary and knitted a
And now
beautiful.
she's in college, right?
No,
She's
but
out.
she is.
But she's
turning-
almost.
She is having her sweet 16 party
Sadie
next
is-
weekend.
Oh, my.
And
That seems just unbelievable for
Right.
those of us who were here before
Yes.
you were even thinking about Sadie.
so it's nice
How
to
lovely.
see.
So that's
Nice to see you still doing that.
I am. This is a wedding present.
All right, well, I love the color. It was great that Pepper gave you a good overview. I will just say that, you know, going back to Mike's comments, is that this is really housekeeping, and I'm going to go through where I'm going to highlight certain things. If I don't mention language that's struck or underlined, you can feel free to point it out to me, but it's just more probably technical or chewing it up with another kind of more substantive change. The things that when you talked about the medical program and should shift over, I just wanted to note, as I mentioned, when you passed the adult use system, setting that up in 2020, you did include in 7 VSA, I think, section 971 about the intent of the legislature in maintaining a robust medical program. And it is the board that is responsible for running this and making sure that both programs provide. So, and they've got so many, they've got all the stakeholders and connections and things like that.
Exactly.
So I just wanted to kind of give a little bit, these are the folks who
Oh,
can,
yeah, no,
who
I-
can figure that out. And they're, you've already essentially tasked them with that.
right.
So,
So I think that's, we don't want to reinvent that wheel. So we want very much task the appropriate body with coming back to us. But I think it's time for us to do that. To do that work and figure out how we can honor that intent, but also streamline it so that it works in sync together and not in competition, and so that we maintain all the benefits that patients have, but also integrate it into a system so that we make both robust and into the future.
And then a couple other things I just wanted to remind folks of, because you brought up the issue about animals getting into something. And so the board strictly regulates cultivators who are licensed under their system. But as you know, prior to establishing the adult use, I mean, we had the medical, but we also, the General Assembly legalized for any person 21 years or of age or older to be able to cultivate up to 2 mature and 4 immature plants. And then they could, whatever they harvest from those plants, as long as they keep them there on that same property, they can keep that, and then they can have a separate ounce, basically, of kind of their personal amount. So that issue is around, I think, more kind of
going in the
any person doing that. And so that's a kind of a different area that the board does not regulate.
Okay.
How we dispose of used up plants.
If you're not a licensee, correct?
Yeah,
Like
you're
if it's
good
just
for Marjorie,
someone,
you throw it in the compost pile
Right.
and never think that your dog might eat it.
correct. So,
Just secure.
and then on the other 2 issues that Pepper mentioned, there's nothing in here around the cannabis regulation, the cannabis business fund in here, but we can take a look at that if you want to at a future hearing, and I can bring up the
That
language
sounds
and we
like
can
a
take a look
good
at that.
thing.
And neither is there anything around the issue of cultivators being regulated by municipalities around zoning or things like that. There are provisions in our existing law. So when you passed it in 2020 around what municipalities can and cannot do, they do retain their zoning authority. And I think some issues have kind of arisen around that about how some municipalities might be interpreting the statutory language and kind of maybe trying to push it a little bit. And you can take a look at that. And then the other issue that's kind of been brought in is whether or not cannabis should be treated like hemp and treated as an agricultural product and treated as farming, which is a much bigger issue than I think the specific zoning issue, and whether or not municipalities are really in true compliance with the spirit of what you passed in 2020.
Okay, because marijuana is not farming, because then we'd be in all kinds of trouble with the feds and federal grants. And we dealt, I think it was last year, we dealt with a bill in which we had to deal, with small cultivators, I guess.
Small cultivators, you did allow, so there is some room there that small cultivators, the 1,000 square feet or less,
Yeah, and this
are treated. Yep.
Yeah.
Are treated as what?
There's an agricultural exemption from sales tax when you're buying.
Right.
And we made it clear that even though it isn't technically agriculture, because of the federal exemption, that, but if you go in to buy a pair of clippers, you don't have to say if it's for your marijuana or for your carrot plants.
Right, there are some specific things that were allowable for the small cultivators. And then I think when you talk about the cultivation piece and how that works with how we're treating hemp and land use and all those things, you should have Michael O'Grady come in, because he's been the one that's been working on that because of his ag expertise, which is not me.
Ag, therefore, I can see where towns, if they wanted to, could say it's excluded from agricultural zoning and it's not allowed in medium density residential or.
I'm sure there's a number of issues. The one that I had heard about was really, so you have a provision in the law currently that says that towns are not permitted to adopt rules or bylaws that essentially prohibit cannabis establishments if the town has voted to allow them. I think though that perhaps maybe some municipalities are looking at how to, I guess the issue is,
you might not prohibit them specifically in your bylaws, but if you in fact adopt a certain number of zoning restrictions that essentially winds up that nobody could possibly comply, you might be effectively prohibiting those types of businesses.
Because there were, maybe there still are, rules that say you can't open a bar within so many feet of a church or a school, you can't.
Mhm.
But if you've only got 2 blocks and your church is on either end and your schools, I could see where that could zone out a business, but it would also zone out a liquor store, so.
Yep. So O'Grady and Tucker are your folks there on the municipal regulation of land that might be used either for.
Right, and they, we would unleash them in Bobby, in Senate Ag.
Okay.
Then we'll unleash Bobby.
Then we'll unleash Bobby. Oh my God, if Bobby gets us excited about this, and these is about universal meals, we'll be set.
Okay, I'm going to start walking through the bill, if that's okay.
Please.
So I love that you guys still enjoy a hard copy. I do as well.
Oh my gosh, this is where I make all our dear notes.
I know, I like that too. So working off the as passed by House version in section 1. So when the Cannabis Control Board was established, the General Assembly also established a Cannabis Control Board like advisory committee. And for those of you who were here before, you might recall this was the idea of having a number of folks who have expertise in certain fields, whether it be agriculture or laboratory science or healthcare or things like that, being on an advisory committee that could really help the board in developing their rules and kind of setting up the system and guiding the system and making sure that they're covering all their bases. And so the first section of the bill is repealing the advisory committee.
Is it no longer useful?
I think I will just wait. I'm going to walk you through everything, and just since we have Bryn and Pepper here, I will let them answer as to why. Again, this proposal did come from the board, and so they can offer you their justifications for why.
Well, that's easy. Section 1 is a full repeal.
Yes. So page 3, section 2. So again, in the initial legislation in 2020, there was a lot of debate about what should this new agency, this new regulatory agency look like. And it was set up as an independent executive board agency. And there are 3 members of the board. There was, difference of opinions at the time about whether or not this was the right structure for continuing to have an agency look the way that it looks. And so there was a bumped out repeal of the board put in that 2020 legislation. So the board, and it was essentially done so that the legislature would come back and take a look at, does it still make sense to have the agency structured in this way? And they also required a report from the auditor of accounts prior to that repeal. In the Budget Adjustment Act this year, so the auditor's account was due this year in this November, and the auditor came in and said, we really need to see more time of how this is unfurling. And so in the BAA, that auditor's account is bumped out 2 years to 2025.
So we did that in the
BAA. And the board has asked that this repeal of the board be eliminated, but you will be receiving that auditor's report in about 2.5 years.
So by repealing this sunset,
it just means that it's just going to leave. You obviously can repeal it at any time or do whatever you want. You can wait for the auditor's report or not. This is just taking out that because this is due to repeal next year.
Right.
So the next section is on section 3, and this is in the definition of advertisement. And there's a small change here that was requested by the board so advertisements right now, if you're going to be advertising in the adult use market, there are a list of
restrictions around what you can and can't do around advertisements. And prior to putting out an advertisement, you have to have it approved by the board. So the board has to see what your advertisement looks like, what it says. And if they feel as though you need to make some tweaks, you need to go back and make some tweaks, but you can't publicize that advertisement until you've gone before the board. And you'll see the language there on lines 14 and 15 and 16. Right now, it says that advertisement means any written or verbal statement, illustration, or depiction that is calculated to induce sales. And that's just being changed to would reasonably have the effect of inducing sales. And I think Brent can talk to you about why they feel is that that's a better legal standard and more easily defensible for them to apply.
One might argue, do they need advertising goals? I mean,
There was
the word of mouth on it is so strong.
You did, again, in the 2020 legislation, because advertising was a contentious
Right, I
issue,
remember.
tasked the Attorney General's office with coming back to you with a report and a recommendation, and they felt as though banning all advertisements was constitutionally suspect.
Yeah,
And
yeah.
did not recommend it, so.
Okay.
Top of page 5, so this is in the and still in the definition
So we
section.
just have another change at the bottom of page 4 on line 16.
Yes, and so
Modest.
again, it's just a technical, so there's a lot of little technical things. This is just adding the new propagation cultivators to the list of cannabis establishments. So right now you have cultivators, wholesalers, product manufacturers, retailers, testing labs, and then integrated licensees were those special licenses that were just granted to the existing dispensaries to allow them to be in the adult use market under an integrated model and being able to do everything from, cultivation to point of sale. And this is just adding the new propagation license to the definition of cannabis establishment. And you'll see
These are the ones who are creating the starts.
Right, so top of page 5, you'll see the new definition of the propagation cultivator. And again, it's similar to like a nursery license, so that folks could be could have clones and immature plants that they would then be able to sell to other licensees. So
Could I get down and buy 3 plants?
no, I don't, I'll go through
No,
what they can do there, but
not gonna
no,
be at
this
our
is just,
I gotta
no.
take a chance with my seeds, my black thumb, okay.
It does, they would allow I think the propagation cultivator to sell seeds, but we'll get, there's another section here and we'll look at those provisions. So section 4 is for rulemaking. You put a lot on the board in terms of developing really all the minutia detail for the market. And the language isn't there, but in subdivision A1, it has a very long list. I might go into even the double letters on the subdivisions about the types of things the board has to develop and have in their rules for all of the licensees. And then like 2 through 8 have ones that are specific for each type of license. So I just wanted to note that, because when you see something here under a particular licensee, if you're saying, well, what about security? Or this is probably an A1, which I didn't reproduce because we're not changing that. The first change is starting with subdivision 3, and this is with regard to the product manufacturers, and Representative McCarthy already spoke to you about that. Currently, for a cannabis product, it's limited to 50 milligrams of THC per package. So the adult use 21 and over, if you're not on the medical registry, your possession limit, whether you buy it from a dispensary, whether or not you grow your own or whatever it is an ounce. And so that is not changed at all in this bill. And so like if you go to there's a shop down across from City Hall here in Montpelier, if you went in there, then you would have a cap of an ounce, right? And this is really just saying that, like, if you were going to have your limit, it's about how much is in each bottle. And so initially it was, in the way that it is now, is that it's only 50 milligrams of THC per package. Again, that doesn't affect the limit that you can buy at the store. It's just how many bottles it's divided into.
So
It's the only
it goes
change.
to the packaging concern.
Yes, it's just like if you went to the liquor store and you bought a little airplane bottle, or you bought the little pint
Or buy
bottle,
the airplane bottle.
Or five airplanes.
or whatever, things like that. You know, it's just about, it's really just about the packaging.
No, it doubles the price of the stocking present. Right,
Yes,
got it.
it does.
It's,
Or more.
yeah.
So the next change is at the bottom of page 5, rules concerning retailers. And right now there's rules regarding facility inspection of retailers. And the Department of Health, who's working with the CCB on inspections, I believe asked for that clarification that these facility inspections are to occur at least annually.
So given we haven't had a full year of this, are we, well, we've had more than a year. Are the inspections actually happening in a timely fashion?
Well, again, this
We
is
know.
under for retailers and,
Right.
and we haven't had a year
I
of,
know, so I'm just
So
curious if
I would
any
say-
inspections of anyway, we'll find out.
Yep.
And how many, I mean, given, I guess we add this to their restaurants and stuff. I mean, the Department of Health does already, they do. I mean, they do inspections of a bunch of other things, right? Right. I think.
Yeah,
Not.
yeah, but they do a lot.
Okay,
But didn't it come from the Department of Health that asked for this, or am I wrong, that provision?
I'm
That
happy
change?
to talk about this.
Oh.
This is about streamlining, like the authority of the Cannabis Control Board and the Department of Liquor and Lottery.
oh, this is
Okay.
DLI.
Oh,
Okay.
But
Right,
it
sorry.
implicates GDH also.
Okay.
Okay, we will hear more.
Page 6, you'll see at the top of the page, the new rules that must be adopted concerning the propagators. You'll see it's just verification for age of customers, rules around pesticides, standards for indoor cultivation, standards for testing. Again, these are also elsewhere, so there's a little bit of just overlap. There's labeling requirements, regulation of visits, and then facility inspection requirements. And again, those are in addition to all of the rules that would apply to all cannabis establishments.
Is visitors, is that defined somewhere?
Visitors, I don't think so,
It's an
but
interesting word. It's
Um,
like folks who are not customers. as you might
well, it
say,
could
or
be,
inspectors.
it could be that if you've got somebody coming to work on your watering system and your plumbing or your,
Oh, like
you know what I mean? Like it could be
people.
any kind of people that are there on site.
That are not customers.
Right.
Okay, okay.
So
Agro-tourism, sort of, you know.
That could be an issue. But okay,
Or an
but I see why you would want to have rules on that.
The ideas.
Oh, sorry.
Okay.
So section 5 starts at the bottom of page 6. And the language that is affected is the top of page 7, and this is essentially repealing the language around the public access to records at the CCB. But don't panic, there's new language in section 6 that adopts a new policy around this. So you see subsection A talks about that it's the purpose of the section to protect the reputation, security practices, and trade secrets of licensees from undue public disclosure while securing the public's right to know of government licensing with regard to public health, safety, and welfare. Subsection B, just stating that all meetings of the board are subject to the open meeting law, which is current. Page 8, subsection C. C1 is essentially the same as what we have currently in law. The new is language is going to be in the new subsection D. And this has to do with when there are enforcement actions by the board or they are responding to complaints. So you see in the lead-in language starting on line 8, if a complaint or investigation results in some type of formal action by the board against a licensee, then that information is to be public. However, you look at subdivision 2 is that in cases where there has not been some type of formal action by the board, there is going to be some information that's public, but then some information that would not be public. So if there, so the board is required to prepare, maintain an aggregated list of all the closed investigations into misconduct or noncompliance. And that information in the list is to be a public record. And the list is to contain the date, the nature, and the outcome of each complaint, but doesn't contain the identity of the subject of the complaint. And those are in the cases that don't result in some type of reprimand or suspension or revocation or fine.
Quick question, is this consistent with the way that we regulate alcohol?
I don't know.
That's a Britain question.
Well, that's, okay. So-
Yeah, I would assume, and or a Tucker question.
Okay.
And then subsection E is just our standard language that I'm sure you guys have seen before, which is that it's just, there's not an automatic, there's not a repeal through operation of 317. So moving on to section 7 at the top of page 9. This is tweaking the cultivator license to make it clear that they can be doing business with the new propagation cultivators. And then you'll see the new language on subdivision 3 is that they would also be able to possess and sell cannabis products to a licensed wholesaler or any of the other types of licensees. Section 8 is the statute creating the new propagation cultivator license. So you see, we already talked a little bit about what they can do. They can cultivate not more than 3,500 square feet of clones, immature plants, and mature plants. They can test, transport, and sell clones and immature plants to licensed cultivators. And they can test, transport, and sell seeds that meet the federal definition of hemp to a licensed cultivator or retailer or to the public. So they can sell hemp seeds to the public.
Single seed, there you go.
No,
So Anne can buy seeds.
Pardon?
Anne can buy seeds.
Buy hemp seeds from a propagation cultivator.
Right.
no, that's, it's hard to buy. I'm remembering my daughter, when she was in the extension service, and they had a hard time getting hemp seeds because federal law required they were irradiated, so they wouldn't propagate. Is that still?
I do not know, but from my people. they answer that
Okay,
question.
so I couldn't go to Agway and buy hemp seeds.
No, I don't think so.
Okay.
Someday, maybe, maybe not tomorrow.
So page 10, section 9 and section 10 make the same change, and actually section 11 make the same change, which is just that when you did the initial legislation, you kind of did it, this licensee can do business with this other licensee, and then and I will be honest in that we were really just kind of guessing about who needed to do business with one another at the time. And then what the board has said is basically they've asked for some tweaks to this so that basically if you are licensed and in compliance, you can be doing business with any of the other licensees.
So
It's not-
all licensees can kind of do business together.
Yes,
Which makes sense. Now they can't buy each other, right? Because we wanted them to stay small.
right. There are restrictions in terms of people can only own one of each type, only have one of each type of license. So you could have someone that decides I would like to be a cultivator and a product manufacturer because I want to grow and then I want to turn it into a salve or a tincture or something like that. But you would not be able to say, I would like to have 3 stores,
Okay.
3 retail stores.
But you can have an integrated license of, I mean, you can have a license from start to finish.
But not one license. You can.
Right,
would
you have to have a
get one
license
of
for
both
each thing.
licenses.
Okay. But you can have a license.
And then
for-
there's tiers within each license category depending on the scale.
Great, thanks.
Okay, so that takes us through
And
section
that takes us up to
12.
section 12. So there we're starting to look at fees. And there's a small tweak to the fee for manufacturers is right now, you see for manufacturer tier 1, what qualifies as tier 1 manufacturer are folks who process and manufacture cannabis for the purpose of making products without using solvent base extraction, and they don't have sales over $10,000. This is just changing that to that they don't have sales over $50,000.
Are people, well, I guess it's a question for Brent, but clearly people are hitting that $10,000 mark already.
And
One
then-
assumes.
And then the next change is on line 7, establishing the new fee for propagation cultivators. So it would be a $500 annual licensing fee for the propagators.
More income.
And there is a
Let's
fiscal,
bank that.
there is a, I don't know if Scott has it around, but there is a fiscal note from the House on this.
Good, Scott, if we could get that, that'd be great.
So page 13, section 13, we're going to move on to the medical cannabis registry. So the registry, Vermont adopted the registry in 2004.
Amazing.
And dispensaries you allowed for dispensaries in 2011, but right here, we're just working within the registry provisions. So just a refresher on the registry, which is that you have a list of qualifying conditions. Someone who could go to their healthcare provider. The healthcare provider, if willing, could sign a form, a medical verification form, attesting to the fact that they have a patient healthcare provider relationship with this patient, and that the patient has one of these qualifying medical conditions. The provider is not saying, I'm recommending this, they're not prescribing it, they're just saying, this is one of my patients, and this patient has this particular medical condition. And then that would be submitted as part of the patient's application to be on the registry. And then that patient would have the benefits of being on the registry, which means that they could cultivate a little more cannabis than you could if you were not on the registry, but and this changes the number, but right now it's for adult use. Like if you're not on the medical registry, it's 2 mature, 4 immature. If you're on the medical registry, it's 2 mature, 7 immature. So there's really not that much difference currently since we adopted the allowance for over 21. But the patients can grow a little bit more, they can possess a little more, so they can have 2 ounces. They can also avail themselves of the dispensary and the benefits of the dispensary, as Pepper was talking about. So this first change is on the definition of qualifying medical condition. And as Representative McCarthy mentioned, so the initial legislation expanded the list of qualifying medical conditions, and
Right.
There's been bills on that for as long as we've had the registry, and
Every year we seem to add.
right. And so that has had a hard time making it over the finish line. It was in the bill as government operations considered it. Human Services took a look at this section, and they did not want to expand the list of qualifying medical conditions, and so government operations and the House took their recommendation. But they did make this one small change, as Mike had mentioned. So currently, post-traumatic stress syndrome is a qualifying medical condition, but you'll see in the language that struck out on lines 16 through 18 is only if the applicant is undergoing psychotherapy or counseling with a licensed mental health professional. And so this is just changing that so that it's taking away that extra requirement if that's their basis for why you're on the registry. So your medical provider would just say, yes, this person has PTSD, rather than their PTSD and they're in counseling.
Okay. The other ones are pretty much incurable, pain or something involved. PTSD is pretty much a psychological disorder. And after World War II, people that came home with PTSD, because no one knew what it was, self-medicated with alcohol by and large.
In World War I.
In
Huge
World
after
War I,
World War I.
yeah. We called it shell shock then.
Yeah.
But we didn't give them an open buy to the liquor store. I'm not sure it's in the best interest of people not to be receiving medical treatment or some kind of treatment or counseling for something that can be helped, rather than just saying, well, you don't have to go to the doctor if you have PTSD. You don't have to do anything. You can just self-medicate.
But you
You
need,
do have,
you need a
you
recommendation.
need the medical
Yeah.
verification.
Right, that you have PTSD.
Mhm.
Yeah,
But PTSD, unlike Parkinson's or other, physical disorders, it can be made a lot better if you receive treatment for some, maybe many people. I'm gonna need a little.
I hear what you're saying, but this
That this is-
means you have to have, I think what I hear you saying is that it's important for people with PTSD to not only maybe have marijuana if they want it, but also to be getting counseling. This is not, I think, what this is saying. This is saying this needs to be the second check on the box before you
Correct.
can get it.
Right.
And I think that one would hope that anybody who was suffering from PTSD would be getting therapy. I don't know if you can require that here, because I think that's what I hear you saying, is that it would be good complement to the taking marijuana to also get good counseling.
Yeah, I mean, most of the others, maybe glaucoma, not so much, either cause you a lot of pain or they are terminal. PTSD, other than suicide, is not life-threatening. I just think of all the alcoholics that were created, and I don't want to recreate that here.
I hear you, and this is, I assume, one of the sections that we would want to have health and welfare take a peek at. Is there another section other than section 13?
Section 13 is the entire medical.
Is the whole schmagag?
All the
Yeah.
medical suites, so.
Okay, so let us think about that, but let's also ask Ginny's committee to
Mhm.
take a peek at it.
And so just a reminder is that, so a lot of, this is built off the previous medical system
Yeah.
when you could not legally possess cannabis. So if someone doesn't want to go through this, they can still walk into any retail store
That is true
and
now.
purchase. So
Yeah.
I just kind of want
You're
to
right, that's changed. the
remind
whole
is
thing.
that it's
I can walk into the liquor store.
the ability for this, so if someone has PTSD, they can choose to go through if they have right now, if they have counseling, they can get through and they can go on the registry, which means that, as James mentioned, there might be certain products that have a higher CBD level, lower THC, there might be certain products that they could obtain on the medical program as opposed to the retail or other things, but somebody can, if they want to choose to self-medicate, they don't need to go through the registry to do it, I guess I would just say.
Does the minimum age requirement apply to medical use as well? as-
No, it does not. There are folks under 21, and probably the board can tell you how many for the
Right,
under
and it
21.
needs doctor's recommendation, but I mean, it's basically a prescription, form of prescription.
No, it's still the same
It's
thing. It's
still-
a medical verification
it's a
form.
medical
It's not
but
a
it's-
prescription. You're right.
Right.
Sort of being medical,
Verification,
okay.
they want.
I mean, the thing is that medical providers always
I
have
hear
a choice of whether or not to sign the medical verification form or not. And again, if you take testimony on that, there's some that are medical professionals that are perfectly fine doing it, but they're under no obligation to sign the verification form. So if you had a medical provider who either does not believe that their patient should be using cannabis, period, or they don't think it's appropriate for a particular patient or something, they are under no obligation to be able to sign that.
But a patient can doctor shop too.
Sure.
Are there any limitations regarding the amount that can be purchased for medical purposes as opposed to commercial purposes?
Yes, it's 2 ounces instead of 1 ounce.
Yeah, it's double. I
And
think,
in terms of the 1 ounce versus 2 ounce, was there any method by which those quantities were determined? I gather you can possess what 1 ounce or 2 ounces, but you could buy now 50 and up to 100 in this bill, right? Milligrams.
No, so before,
package.
until the adult use, you didn't really regulate THC content. It was just around focusing around how many plants you could have, and the amount of essentially like usable cannabis, or the equivalent of an ounce of usable cannabis. Of, you know, like they have these calculations for what you do if you're using tinctures or edibles or other things. But the THC, there's still, this doesn't change the amount you can buy either in either market or possess under either.
Right.
This is just the THC that's tweaked is just about how many packages
You
it has
can
to be
buy.
and divide it up into.
Well, would you take that 1 ounce, for example, that you can purchase and divide it up into smaller units that represent what's in that 100 milligrams that you can buy into this? I'm missing the difference between the 1 ounce of possession and the 100 milligrams that can be purchased in a single package. Are we talking about the same item, the same substance that's inside the package that's in the 1 ounce that you can possess?
You know, I might kick that to the board to talk to you about how they determine the conversion between the products. But yes,
If I do a straight conversion, you can purchase 283 ounces or 283 packages at a single time. And I'm wondering, are we talking about the same thing by virtue
no,
of conversion?
THC and how many milligrams of THC is in
That's
the product
THC and
is-
not.
and is not the ounce of the amount
And
of
then we
cannabis you
can
can
talk about
buy.
the conversion.
Yes,
Okay, that's fine.
yes.
Okay, I'm just cognizant of our time. We only have,
We're almost done.
okay, I would just like to keep us on track so we don't have you for that long. So
Sure.
we'd like to keep going. We'd like to hear from Bryn. And I may ask those when we get there.
I have a tiny legal question on medical.
Yeah,
The doctor's, whatever it is, a note, is it a recommendation or is it just a confirmation of the condition?
it verifies the
Second one.
condition.
It is
Okay,
a
that's
medical
all I need.
verification
Otherwise, they
form.
lose their
It's a
license.
standard form.
Okay. So it's just a
we can-
confirmation that they have the condition.
That's why it's called a verification.
Got it.
Yep.
Thank you.
So page 14, so amending the section on the registry, you'll see this is around the amount of that patients or their caregivers may possess, and you'll see the change there on line 6 going from 2 mature to 6 mature and from 7 immature to 12 immature. There's no change to the 2 ounce possession limit. Bottom of the page, section 954, this is with regard to caregivers. So as James mentioned, folks can designate a caregiver. That caregiver would have to be registered with the board. There's currently a requirement that caregivers have fingerprint supported FBI criminal background checks. This is not, I just want to clarify because I think there's a little confusion in the House. This is not kind of just authorizing, you know, kind of the bigger issue around what somebody is, a person's caregiver. What the caregiver would be able to do essentially is pick up the patient's products at the dispensary for them, or could assist them in cultivating at home or things like that. And so there's a change here at the top of page 15 that would be getting rid of the fingerprint supported national background check in favor of a name and date of birth, Vermont criminal record check. So it would just be Vermont convictions, and then they would also be checking both state protection registry, so both the Child Protection Registry and the Vulnerable Adult Abuse Registry. And I would say, let's not spend too much time on that because I think that the registries actually have some suggested tweaks, and I think you're gonna hear from them, and we'll come back to that. So on page 16, subsection D, there's a tweak there. So currently caregivers can only serve one patient. There's a change there on line 4, is that a caregiver would be able to provide assistance to up to 2 patients under this change. And then you'll see another change on line 7. So if you have a patient who's under 18 years of age, right now, they are allowed to have 2 caregivers. So if you're thinking about if they're cultivating at home and it's the, the child is living with their parents. And then this new language is added on line 8, which is that additional caregivers shall be at the discretion of the board. And that's to kind of take into account if you have a child who's, splitting their time between 2 parents' homes, and there may be, step parents, things like that. So, but that would be just at the discretion of the board. Section 955 are the registration fees for patients and for caregivers. And right now that's an annual re-upping, and there's a $50 fee every time you renew your license. And the change here is that they're proposing that only folks who are on the registry because of chronic pain be required to do the annual registration. And this goes a little bit to Senator Cummings' issues that, there are some medical conditions that are intractable, and they're not going to change. If you have MS, you have MS, and that's not changing from year to year. So should you have to go and get a letter and renew every year from your provider, if saying, yes, I still have MS, but chronic pain is something that may change from year to year. And so the proposal here is to say, if you have one of these other conditions, you only have to renew every 5 years. But if you have chronic pain and that's the basis for your qualifying on the registry, you do have to stay with the annual. And there is a fee impact to that, and that's contained in the JFO fiscal note. So the next change is top of page 17, and this is on rulemaking. And you'll see that language that's struck on lines 1 through 3. And this was part of the original legislation setting up the adult use that had some provisions in there for medical, which is that no rule that the board adopts with regard to the medical program was supposed to be more restrictive than the rules that were adopted by the Department of Public Safety, which was the previous regulatory authority for the medical program. And the thinking around that was that the medical program formerly was fairly restrictive, but then there were other areas where they didn't address at all, like testing. And so this language now is a hindrance to the board to being able to fully regulate in the way that they need to, and to true up those 2 programs in a way that makes sense. And so they're requesting the repeal of that language. Section 14 is just clarifying that if you are licensed by the board and as a cannabis establishment, but you also have maybe pipes or smoking implements or things like that, that doesn't mean you have to then go to DLL and also obtain a tobacco license. And so there's just a little clarifying language there. And then the effective date is this summer.
For all sections?
Yes.
Great. Thank you. Any questions from Michelle?
Pay the same tax. We tax tobacco paraphernalia, like pipes,
Yeah.
cigarette holders.
We do.
You pay the same tax on cannabis paraphernalia?
I don't know. And I know there's been lots of folks going round and round on that kind of stuff in the last couple of years, but I can find out for you.
Okay, we can do that, because I assume the fees will show up at some point in finance.
Yeah. Mike, I would assume we charge sales tax on it, unless it was in the medical dispensary. I think in the
Right.
dispensary we don't.
It's, I think there may be other taxes for restriction. I just want to make sure.
Yeah, Anthea's been the one that's
been.
been handling all the
Yeah.
taxation stuff on that.
Yeah,
And so
we'll
I'm,
figure it out.
but I can follow up.
Okay. Thank you
And I'm not
very
coming
much. This
today,
was
so.
terrific. And I think we were supposed to have a break at 10:30, and I think I'm just going to let us take individual breaks as needed, because we really need to be fully kind of teed up on this before we then go off and hear from other people. So I'd love to hear, if you don't mind, we're going to go to Bryn and our executive director. Hello, Executive Director Bryn, former legislative council. It's lovely to have you in
Lovely to be here. Thank you for having
your not so new capacity, but
me.
Good background.
Yeah, it is, absolutely. So for the record, Bryn Hare, Executive Director of the Cannabis Control Board. There were a lot of questions that came up. I feel like the most expeditious way to address all of them is just to go through the bill, section by section, to talk about the rationale for each section, and hopefully we can get to everything that came up during the previous testimony. So I will do that, if that works for you.
that's great. We have until about 10:45, 10, and we can always hopefully have you back 10:50, and we're gonna try and do, wanted to have the three of you all present at the same time. We also sadly have 4 weeks to do all
I
of
know,
it, so we need to shift fairly soon.
no problem. So I will
Right.
scoot through as much as I can.
Great, no, very, that's super helpful.
So section 1 is the sunset of the advisory committee. The 14-member advisory committee was very helpful to the board as we set up the original legislative or regulatory framework for the adult use industry. At this point, we have done so, and we are,
Their work's done,
their work is done. And so we are suggesting that they be sunset at this point.
and the boards and commissions task force would be thrilled to have yet another group disbanded, who've done their work.
Yeah, so section 2 is the repeal of the sunset of the Cannabis Control Board, and I think the chair mentioned that this does not mean that the structure or form of the Cannabis Control Board will not change in the future, but there are some administrative functions that are difficult, given that this sunset exists in statute. For example, hiring staff who are curious about whether their job will go away in 3 years. Finding physical office space has been a challenge because BGS has been curious about whether or not we will still exist. So those just sort of basic functions have been challenging. And again, the auditor's report will come in November of 25 and give you an indication of whether our structure is appropriate. And at that point, you can sunset us or do what you like.
Keep going, that's good.
All right, so section 3 is the advertising, the tweak to the advertising law. Under current law, that language provides that any public statement, illustration, or depiction is an advertisement if it's calculated to induce sales. And because the board has to review all proposed advertisements before they can become public and sign off on them or not, this puts us in the position of trying to establish what the subjective intent was of the business in submitting their advertisement. So changing that language to, any statement, illustration, or depiction that would reasonably have the effect of inducing sales allows the board to make more of an objective determination about what the effect of that proposed advertisement would be.
May I just, it strikes me that this is onerous to have you reviewing every ad that is out there. I mean, at a certain point, this may just become too much, right? Maybe for a more substantial review.
Quite a bit of staff time to review all proposed.
Yeah, and there are how many staff now?
20.
So it strikes me you could have one dedicated staff person doing all those ad reviews. I mean, it seems to me a little micromanaging, but hey, we aren't going to change that this year.
Well, this is what the legislature told us to do this, so we are doing it.
Okay, but we would recommend a recommendation at some point in the future for a way to make it a little less micromanaging.
I would want to talk about that more, actually.
No.
I thought you banned advertising.
Yeah, I mean, I don't.
Well,
wanna-
there we have the range.
Yeah.
And the word of mouth, my guess is it's number one seller, as word of mouth is for most things.
So I will get to the cannabis propagation license when we get to the big section that deals with the cannabis propagation license. So I'm just gonna skip to section 4.
Okay, so, but for ag, this is the sections that we're gonna have them review are sections 4. No, yeah,
Yes, it's essentially the only portion of section 3 that has to do with
Right.
cannabis propagation. cultivated
section
ag
3
and
bits,
ag.
and then section 4.
Yeah.
Is that right?
Yes. So in section 4, the first thing that we do in section 4 is to increase the per package THC limit. And as the chair mentioned, we do have a legislative mandate to incorporate principles of environmental sustainability into the regulatory framework. There are requirements in law that cannabis products be packaged in child-resistant packaging. And that means that the industry is really reliant on these non-recyclable, single-use plastics. And it's going to be a major contributor of consumer waste, having a brand new industry that relies heavily on single-use plastic. So we have incorporated these principles of environmental resiliency into our regulations in a number of different ways. One of the things that we did in our rule is to ban plastic from the consumer packaging unless it's necessary to achieve those child-resistant requirements.
Good work.
So we are also encouraging packaging take-back programs and reuse programs at the retail level, encouraging sort of bulk sales that allow for reuse of packaging. But this amendment that would permit 100 milligrams of THC per package for edibles is just in line with that sustainability mandate that the legislature gave the board. So I think that you've heard from the witnesses this morning that this would essentially just allow a consumer to purchase one full package of edibles instead of 2 half-empty packages of edibles.
What I'm trying to understand is just the conversion rate.
Yes, so the conversion there, we have on our website a guidance form for retailers so they can understand what the conversion is from that that possession limit of 1 ounce to the amount that that would translate into for a concentrate, for example, or an edible or some other type of product. So
We're passing here. I just put cannabis store in maps and talk about advertising. There's all the cannabis stores in central Vermont. I didn't know about those.
But that's a fact. It's a
fact,
question.
but
It's a
I mean,
fact.
if anybody wants to find
Oh, yeah. So
cannabis. you
all they
just
need to know
Google
is
it.
where it is. Right. And that's a fact, and that's on Google Maps.
Yes, so you don't need to advertise to get people to come to your store.
Okay. So,
I think
sorry, I just wanted Bryn on this to send to Bobby. This would be section 14 from E on. We would
correct,
have ag look at, right?
correct.
In section 8. Section 8 as well is the property.
And that's what,
Yes.
yes, section, well, yes,
Reform.
D, from in sections 3D8, and then in sections 4E, all the way through F, right?
Are we allowed to do these fees?
G.
We haven't had a fee bill.
That hasn't stopped us so far this session, happily,
No,
given that we should have had a fee bill in 2017. So,
Can we go back to my question regarding
yeah, the conversion rate.
conversion rate and where they'll find that?
Sure. So the conversion rate is, so 1 ounce of flour, up to 1 ounce of flour is what a person can possess. So that equals 28 grams. 1 ounce is 28 grams. And that 28 grams translates to up to 8 grams of cannabis products in concentrates or up to 800 milligrams of cannabis products.
That's on the control board's website? Is it?
So 800 milligrams is what you're using for an ounce.
Of edibles. So of an
For
edible
edibles.
product, 800 milligrams.
Right. Well, but 800 milligrams is what you're, or just logically, to have a conversion, right? There's an assumption that 1 ounce would be
Right, so the-
800 milligrams. I mean, you have to have
That's
some,
right. That's right. It's so, yes.
you have to
and-
pick a number because it varies. An
Yeah, so
ounce
it's
varies.
based on the amount of THC that's contained in 1 ounce of flour that's capped at 30% potency.
Oh, the 30% potency. Okay, so that's how you manage it. Okay, all right.
1 ounce of flour.
Right, right.
So, and that's 30%, and which is probably its own definition, but that's all I'll ask for now, but does
Okay.
that answer?
Well, it does. I'm looking for that. You said there's a chart somewhere on your website?
There's a guidance document and I'm happy to email it to the committee.
Yeah, because I'm looking at the website. I don't see it. I'm sure I see something that says guidance. Is that where it would be?
Yeah, there's a number of guidance documents there.
So you chose flower as a weight to,
Well, flower
the
is
one
is where the limitation on possession is on flower. So in order to make that apply, make that make sense for other types of products that you can purchase at a retail establishment, we had to do an equivalency analysis.
yeah, no, I assumed.
So how does that work? I had a lobbyist, we were looking at flavored tobacco. Tell me, he went downtown and he had pink grapefruit something in a jar with cannabis, and he had a box of root beer barrels with cannabis infused. How is there flour and root beer barrels? To me, it's sugar and cornstarch. How do we do that? And yeah, I mean, how do you convert flour? Is it an ounce of sugar?
Flower, when I'm saying,
It's cannabis
cannabis flower is.
ground up.
No, cannabis flower is
The
the.
flour,
bud, yeah.
FLOW,
Yes, yes.
Not
LOU.
FLOUR. I think everyone was just thinking.
Okay, that helps my visualization. That makes more sense.
Actually, I was kind of interested in the notion of cannabis flour.
I just thought you ground it
Right, you
up.
probably could make it.
I mean, you make brownies or cookies. I
Exactly, but I
think we were allowing gummy
we
bears.
may need a cooking lesson.
But I have seen
Anyway,
cannabis
let's-
infused.
Would you like to?
Yes, I think we need to have you keep moving because our time is short.
Okay,
sadly.
so the bottom of page 5, so we're still in section 4, but this is that provision that rules concerning retails have to require that annual inspection. So,
So that, right, that's retail.
right, so if the
So that's
cannabis
not Bobby.
retail business wants to sell cannabis paraphernalia, tobacco paraphernalia, pipes or rolling papers,
Right,
even if they don't want to sell tobacco products, they have to get a license from the Department of Liquor and Lottery, a tobacco license, and be inspected by a DLL.
right.
So our goal here is to eliminate that requirement so that we are both like streamlining state resources, not having two sets of inspectors come in and inspect the same business for the same thing. And also eliminate the incentive for cannabis establishments to sell tobacco products. So some businesses may think if I have to get this license for tobacco products, I might as well sell tobacco products. And so this
I didn't realize you could do that.
works yes.
Can you do liquor cannabis?
So you can't, the cannabis products can't contain nicotine and cannabis
Right.
or alcohol and cannabis, but there's not a prohibition on.
So I know.
Selling both at the
So in my general store, I know I have to have a fenced off section if I'm a state liquor store, but I'm up in the kingdom. I can have my state liquor store in one corner and a cannabis store in another section of my general store.
Your store would have to comply with all of the regulatory requirements of the Cannabis Control Board, which
Yeah.
would include like nobody entering the store could be under 21. You have to have an ID check at the door. So.
Okay,
cannabis-
but I-
It's for a general
oh,
store,
can-
I think.
Yeah,
So that's why a general store would not.
would not do it. All right, because you
Unless-
can, and that, I guess, is the fenced off section, and I know we've done fenced off sections for tastings in stores so that no one under 21 can go into this section, which I assume has to have a separate door and entrance and, okay.
Right,
But
but the requirements would be pretty onerous to
Yes.
set up a cannabis establishment.
Okay, within
general.
a general store.
Okay,
So I
well, let's
put it
keep
next
moving.
door.
So this
All right.
this language kind of works together with section 15 on an annual inspection. So just to bring the Department of Health that we talked a little bit about BDH, they receive federal funding that hinges on that annual inspection requirement for businesses that are selling tobacco paraphernalia. So this requirement in statute would ensure that we're not jeopardizing that federal funding by making it a statutory requirement. We do conduct our inspections at least annually of these businesses. So it doesn't change anything for us. just making it a statutory requirement.
Right. I'm just going to say to those of you online, we're just finishing up our cannabis review, which we have these three incredible experts here at one time. So we're just trying to get through the bill. Will probably be another 5 to 10 minutes. We're just going to finish up with Bryn.
So I will scoot along and skip the rest of the language in section.
So sorry,
4.
just section 8 goes to ag is mine, right? Section
Yes.
8 is an ag review, A
Yes.
through G.
Yeah,
Okay,
and so
great.
I'm gonna skip the rest of section 4 because that's also what you're proposing go to agriculture.
Or at least initially, we need to weigh in on it, but yeah.
Yep, and then, so section 6, this is that,
The new policy.
policy on public records. And so this is kind of a blending of the public records policy of the Office of Professional Regulation and the Agency of Agriculture. So it's really designed to balance like the public right to know about what's going on with the cannabis industry and also the board's desire to not prematurely compromise any open investigation of a cannabis establishment. And also the need and desire of our businesses, our cannabis businesses, not to suffer any reputational damage based on what is an unsubstantiated or unfounded complaint about their business. So we're adding language that's specific to investigations. So as Michelle indicated, if an investigation does not lead to an administrative action on behalf of the board, we compile a registry of the summary of the complaint and the investigation, but not any information about the business. So we don't have reputational damage if it's an unfounded complaint.
Right.
But if the investigation does result in a compliance action, then that whole case record would be maintained in the registry. So that would be public information.
Right.
Just super quick.
Yeah.
Just because this speaks to my question about are we treating alcohol the same? And the reason I'm asking is because towns rely on alcohol enforcement when they do the annual licenses.
Right.
So towns would be able to rely on this database.
Absolutely, yes.
For information on dispensaries or businesses in their areas.
Yes,
Okay,
absolutely.
thank you.
Okay, so
Just
section,
to ask, again, on your question regarding a list, the list would not contain any information about a complaint that did not result in any action.
That's my understanding, but if they
Yeah.
got it
Only if
wrong,
there was something that's
Yeah.
action that.
yes, exactly.
which is hopefully the same as liquor, but honestly, I don't know. But it's not as sensitive as it.
So I don't know.
Yeah,
Okay.
I would
Okay, we don't need to
Let's
keep talking about that.
feel it with people who know the answer to that and
Okay.
let's keep.
So the following sections, 7, 8, 8, we're going to talk briefly about, that's the propagator, the new propagator license. I can skip that one since we're short on time and talk generally about these sections 9, 10, and 11.
Right.
And these are those kind of technical amendments to these sections that allow for there to be more flexibility for cannabis and cannabis products to move through the supply chain. So when these statutes were initially constructed, they limited the movement of cannabis product. So for example, a cultivator right now cannot possess their cannabis product. So I think the legislature originally envisioned that a cannabis cultivator would grow the flower and then sell that flower to a manufacturer who would make it into a product. The manufacturer would sell it to a wholesaler who would then sell it to a retailer. It is not happening that way. Their cultivators would like to grow their product and put their label on it, even if they're making their flower into an edible, for example, or into a concentrate. So they are sending their flower to a product manufacturer, and then they would like to receive it back in order to put their own label on it.
Yeah.
So they can sell it with their own label. And right now they can't do that unless they get another license type. So we're requiring cultivators right now to get a wholesale license or another type of license if they want to be able to take possession of their own product back from the manufacturer.
Interesting.
So
So
these
it's sort of like vineyards. I mean, we're about to shift to vineyards. I mean, you want to be able to, you want to grow the wine. Yeah. Anyway, I understand, I get this.
So the changes to these sections would just really allow more freedom of movement of product within the supply chain. It doesn't change anything about who can sell product to the public. Okay, so I'm going to move to, so the fee Yes, so the manufacturer,
So we're down to
section 12.
section 12, I think.
Yes, so that is the tier 1 manufacturing license, increasing that total amount that they can sell in order to be eligible for this license type from 10,000 to 50,000. And what we are hearing from people who are utilizing this license type is that cap is really too low. We used that $10,000 limit because it was exactly what the Department of Health home-based food processor license provided in their statute. So it has a lower regulatory burden. These types of manufacturers can't do all sorts of manufacturing styles. They can they can't use any solvent-based extraction methods. It's really kind of a home kitchen environment. So we've determined that cap is really too low for it to be a viable license type for folks. And because there was such a strong interest in a small manufacturing license type for people who might be doing this as well as something else, we're asking to bump it up a little bit so it can be a more viable license type.
Right,
Propagation cultivation license.
right, our
fee.
new revenue producer.
Right, so that's the new license type, setting that fee at $500. Way of example here is our smallest tier cultivation license cost is $750 for an outdoor cultivator and $1,500 for the smallest indoor cultivation license type. So set, with bearing those fees in mind. So if we're ready, I can move on to section 13, which is the medical program amendments. So the first change here eliminates the need for an applicant who's seeking a medical card who has been diagnosed with PTSD to be actively undergoing psychotherapy in order to qualify. So I will just note that what we have heard from patients is that not everyone living with PTSD that needs the benefits of the cannabis medical program is either in need of psychotherapy or has access to psychotherapy or is ready to engage in psychotherapy, but they may still benefit from the medical program, even if they are not able to or ready to be engaged in therapy. So again, this is a change that's really designed to minimize the barriers to access to the program to continue to maintain a viable medical program. We've got I'm sorry, I'm busting.
Yeah,
I'm
that's
assuming
good.
that you're
That's
ready.
Go for it. I think all the witnesses who are waiting are happy.
We're
No,
pretty
it's
good at
okay. It's a lot to take in. So this is good because it's the work we need to do.
Okay, so I'm on page 14 now. This is a change to the plant count limit for registered patients. So right now, the existing limit is 2 mature plants, 7 immature plants. So it increases that number to 6 mature plants and 12 immature plants. And expansion is designed to ensure that patients have year-round access to sufficient quantity of cannabis for patient needs and also varieties. So lots of our registered patients choose to grow their own because either they can't afford the product from the dispensaries or because the dispensaries are too far from where they live and it's easier for them to grow their own. So most of these patients are growing outside. It's much cheaper to grow outside, easier. And anybody who's growing outdoors in Vermont is lucky to get one single harvest a year. So allowing them to have a few more plants would allow them to perhaps lose a plant to one of the various things that a plant can succumb to, including pests and molds and other things. So it means that patients are able to will help them be able to grow the amount of cannabis that they need to manage their symptoms. Also, patients can have a variety of symptoms that they're trying to treat, and there are different strains of cannabis that benefit different types of symptoms. So there may be one strain that is really helpful for nausea and another that helps with sleep, helps them to get to sleep or chronic pain. So this will allow them to grow a few different strains too if they need to.
And I assume you deal with if they grow too much because we don't change the limit in terms of how much they can possess, which is still only 2 ounces.
That's right.
So if they grow more and have successful harvests, does somebody else store it for them?
So that applies to the amount they can purchase from that 2 ounce requirement is what they can purchase from the dispensary, so that will remain true.
It
But,
says possess, not purchase.
okay, so if they, I don't know then if that would, if.
Anyway,
we-
it's a
we do-
question. We don't need to do it now.
Yeah, we may need to address that.
Yeah.
Okay, so I will move on to, there is the section about background checks for caregivers.
Yeah,
This change is designed to eliminate the need for a fingerprint supported FBI 50 state background check for caregivers. And instead do a background check, a Vermont criminal conviction background check, and a check of the child protection registry and the vulnerable adult registry, exploitation registry. So caregivers play a really kind of limited role. They are often, most frequently, they are adult children caring for a parent, or they are a spouse caring for their spouse. And so requiring them to undergo this sort of lengthy process of the criminal history background check that's fingerprint supported through the FBI is administratively burdensome for them. This would be designed to be cheaper and less burdensome for them
And
to do this kind of background check.
it's more consistent with the goal of not punishing folks who may have had a criminal record because it was illegal, right?
Well, the board is authorized in our rules to determine whether or not a specific criminal conviction it would disqualify a person from
Okay.
becoming a caregiver. Or
So that's not a
right, right.
reason behind this. Okay, great.
okay. So we're on our
Okay.
last 2 sections.
All right, what do we have left?
We have registration fees.
Right, so this is another attempt to make the program, the medical program, more accessible, more affordable for patients. And that is eliminating the annual renewal fee for a person who has a chronic or a lifelong condition. So that consists of all of the qualifying conditions on the list except for chronic pain. So every every condition that would qualify you for the medical program is essentially a lifelong condition. So we would essentially only be requiring them to renew their registration every 5 years. So that would be less expensive and less time consuming for them. And also would make it less burdensome on the cannabis and so forth.
Yes, I was gonna say, along with those ads, and time is being used up.
Yes.
Okay, and then the
And then the
last
last
section.
section is just that other, the other section that applies to the annual inspection requirement for, on the CCB for any cannabis establishment that's selling tobacco paraphernalia. So this would eliminate that requirement that those cannabis establishments selling tobacco paraphernalia be licensed by the Department of Liquor and Lottery for the reasons we talked about before.
Great, thank you. I know that we gave you short shrift, and I'm sorry for that.
Thank you.
This is gonna be back on the docket. As you know, we have 4 weeks to do this. We're gonna delegate a review with ag and with health and welfare. I would love to ask you guys to come back to us with language on your taking, looking at, come up with what you want, with the streamlining of how we, now that we have adult retail and medical, how we streamline it into the future, protecting all the, all the things that we want to protect and get. Anyway, we've discussed it. So that would be great. And we will schedule this next week. Next week's actually pretty full. And I can't remember if we have you on the list for more follow-up next week, but I think it'll probably be the week after. Okay. Great. So we give our other committees some time to look at it. Great. Thank you.
Thank you.
Thank you. What a team. This is terrific. And everybody, how about we stand up for a minute and then we will start in 4 minutes on 470.
Allison,
Yeah.
I just got a notice, I have a 10:15 meeting on dispatch tomorrow.
How thoughtfully scheduled.
I don't, yeah.
Okay, no, that's okay.
I don't
What's
know.
happening? Tomorrow we're doing sports betting. Here, I'll give you.
I told everybody we'd have multiple platforms.
Okay, she's gonna, she said she wants to come over.
Oh, Asia gave us.
Yeah, so that's
So we're
fine.
doing this, we're just doing an introduction to it. I mean,
Okay.
well, we've already had it,
Yeah,
but we're
That's all.
hearing from the different
Okay.
people and anyway.
yes.
And then we are
I'm hoping
doing
I'm back.
minimum wage. Okay, yes, I'm sure you'll be back. Well, it may hijack you forever.
It could. Why they
Thank
did.
you.
Okay, Pepper, thank you.
Oh, no, I really appreciate the extra time. It's like.
No, getting you here, it made no sense to bring you back. And anything else that occurred to you for us to call? What I love maybe two patients of retail, who would you recommend that we think about having retail customer? I really want to start.
I'll think of a good witness list is very streamlined. I mean, if you need any.
We don't have a townhouse.
I just feel like, the medical stuff, you should just go to Jenny.
Yeah, we'll do that.
Just, and I can get patients in there.
Great. That would be great.
Because, you know, how are you? Sorry.
David Tech.
Hello, David Allison.
Nice to meet you.
I'll be back in 2 seconds. And would you be kind enough to